Well, good morning, everyone, and welcome. My name is Michael Gault. I'm an eminent domain and condemnation attorney with a law firm called Bell Carrington, Price and Gregg, located here in South Carolina. I want to welcome you here to our virtual town hall to discuss the Saluda Grade Rail Trail project, the rail trail conversion, essentially. And I want to take a few minutes today to discuss that project, to introduce myself, and just to generally let you know what your rights may be as a landowner in a case like this, and how we may be able to help guide you forward. So, again, my name is Michael Gault. I'm a Union County native, but a Spartanburg County resident. And so this project hits particularly close to home for me just because I know many landowners in the Inman, Campobello, Landrum areas who are impacted by this particular project. And you know, this area is home. It's an area that I consider home for me and my family. And this is a project that I deeply care about and want to make sure that anybody who I consider a neighbor and a friend is also protected, that their rights are protected throughout the course of this project. So let's back up a little bit and talk about why you may have received our letter with a QR code that led you here to this particular town hall today. If you received our mailer, it's because public records indicate that you are a landowner along the current existing Saluda Grade Rail Trail. Now, that trail has been abandoned since around 2001, but this is a significant corridor of about 15 and a half miles in South Carolina, and then across the border, around 16 miles in North Carolina, of a section of rail trail that is no longer in use, but that is now being converted to a rail trail, walking trail, a recreational trail, a hiking trail conversion. And so that a couple of things there that we need to unpack. Number one, this project is beneficial for the public in general. You know, the people that will use this trail probably want to and need to, and they're going to be excited to be able to get out and about and to use this trail. But as a landowner, the impact to you is a little bit different. Although the railroad 20 years ago had the right to use this trail for the rail line, the use now is going to be changed. And in many cases now, this trail conversion will mean that many of your properties are essentially open to the public. You're going to have folks using your backyard or your front yard or your property essentially. And so that affects you, that impacts you as a property owner. And it's important that you and your rights are protected throughout the process. I mentioned that I'm an eminent domain attorney. And so generally speaking, in eminent domain cases and in condemnation cases, some governmental actor, the Department of Transportation or a power company or a water company, is coming to the landowner to say, hey, we're looking to do this project on your property and we're going to offer you some just compensation for it. And those cases can be, a little bit tricky and a little bit difficult, but they're different in that the government is coming to the landowner to say, hey, this is happening. We want to make sure that we can negotiate this with you. These rail trail conversion cases are a completely different animal. In fact, this is what would technically be known as an inverse condemnation case, meaning that if you as a landowner don't take any action, nobody will ever come to you and offer you any compensation for this trail conversion. This is something that is, by all indications, going to happen. And unless you as a landowner take affirmative steps to make sure that your rights are protected, then you will never receive any compensation, and the trail conversion project will still go forward. Essentially, and I don't want to get too far into the weeds in a public forum like this, but essentially these cases require the filing of a claim with the Federal Claims Court in Washington, D.C. That's basically a lawsuit that each landowner files individually against this claims court for the conversion of their property that is likely within the current railroad right-of-way that is now being converted from a rail line to a rail trail. The impacts can be significant. It's difficult for me to talk about potential values or potential timelines because every single parcel in a case like this is different. Generally speaking, the amount of damages to you or the amount of compensation due to you as a landowner will be based upon and determined by the amount of property that you own and how much of that property is impacted or will be converted through this trail conversion project. As eminent domain and condemnation attorneys, this is something that we are able to help you in. This is something that we are well versed with. And as a local attorney, as an attorney based in Spartanburg County, it's a project that I'm available for to meet you on site, to meet you in person at your convenience on the property, to look at your property, to see exactly what the impact may be to you on the ground. And I think that those in-person meetings are beneficial. As lawyers, we can always talk to you over the phone or have Zoom conferences these days. When it comes to looking at the project itself, I can look at Google Maps or aerial views or GIS plans, but there's really no substitute for having boots on the ground to be able to meet a landowner individually, face to face, and to be able to look at the property itself to see what the potential impacts to that property may be. So, just to recap, I don't want to keep you long, but it's important to know that I'm here, I'm local, I can meet with you anytime for those initial consultations. But in the meantime, I would invite for you to reach out to us. You'll see our information in the chat box. You'll see a phone number and an email address to reach me and our team. And so before that in-person meeting, I'd like for you to reach out to us, to call me directly. I love to speak with landowners about potential impacts to their properties. And so call me, free consultation, no charge, obviously. We're happy to look at your property through our in-house GIS software to determine what that particular impact may be to you, and if we think that we may be able to help you moving forward. No cost, no obligation to those initial consultations, and certainly we're standing by to be able to speak with you. I'd like to also address, something that landowners may be concerned with, particularly in eminent domain and inverse condemnation cases, and that's attorney's fees. Our fees are pretty standard in cases like this, meaning we're not going to charge you an upfront out-of-pocket retainer fee. There will never be a retainer fee due or any hourly fees charged to you out of pocket as a result of this case. Instead, we operate on what's known as a contingency fee basis, meaning that our fee is a percentage of the recovery that we are able to recover for you in each individual case. If at the end of the day we are not successful in recovering for you, then there's absolutely no fee, no cost, or no expense due to you as a landowner. Now, those fees can vary tract by tract and landowner by landowner, not greatly, but enough to where I can't make a blanket statement here today as to how the fees work specifically, but they're all pretty similar. And so that is another reason that I would invite for you to reach out to me or to our team just to discuss your particular property, your particular impact, and to allow us to explain how the fee structure works. But you can know that you're not going to have to pay anything out of pocket ever. And if we're not successful in recovering for you, then there will never be any fee due. This is an opportunity for you as a landowner to reach out if you have questions about how this project might work, if you have questions about how our fee structure might work, if you have questions about how long this may take. These cases can take anywhere from a few months to a few years. They vary widely depending on a number of factors that are, again, difficult to discuss in a public forum, but easy to discuss once we're able to look at your particular property and the impact to you individually. So, again, I want to thank you for joining us. You have some information in the letter that you received from us where you found this QR code. I invite you to look over that. My name, phone number, and email address is also located in that letter, but you'll see it in our chat box or video description. I'm Michael Gault. I'm a local eminent domain lawyer. I have friends and neighbors who are landowners along this corridor. I care passionately about this project, and I hope to be able to speak with some of you to see if there's a chance that we may be able to help you moving forward. Finally, and I'd like to close with this. I know that many of you may believe that this project is a good project, that you think it's beneficial for the community, and you don't want to do anything to oppose the project. Well, it's important to know that potential cases like this don't do anything to oppose the project. These are not adverse to the project's creation, to the creation of this trail. There are a number of reputable and well-intentioned entities who are seeking to build this trail project, and we're not going against those entities. This is not a case against Upstate Forever or any of the outdoor nature protection or conservancy groups that are seeking to complete this trail. Instead, this is a separate claim against the federal government for the conversion of property under the Trails Act. This has nothing to do with any local entity or any local organization that you might be supportive of or contribute to even. There are no adverse interests there. And, your claim will be solely against the federal government under the Trails Act. And so I'd like for each of you to know that as we move forward. Thank you again for joining us. I look forward to speaking with you and hopefully working with some of you on this project in the future. Thanks.